Ilya, would you like to take a...
Sure, just briefly. So Michael raises a lot of interesting issue in his insightful commentary. I'm not going to try to address every single one of them, but I'd like to address a couple points I think are especially relevant. One is the relationship between the cases cited in Table 2.1 and the Mill Act cases. In some instances, they're actually the same cases, but in some cases, it was in fact in a Mill Act decision that a state Supreme Court adopted or first adopted a narrow or broad interpretation of public use. In other cases, there are Mill Act decisions which don't necessarily resolve that questions, but I felt I should address them anyway in the separate part of the paper because the Mill Act decisions are in fact commonly cited as providing support for the broad interpretation of public use and for the idea that that was the dominant view. Now, Michael also raises a question about, well, how do we treat Mill Act decisions which are based on acquiescence? I think that if, in fact, the Mill Act decision said, well, because of this acquiescence, we generally adopt a broad interpretation of public use, even though we might not otherwise, I would count that, just as Michael suggests, as an endorsement of the broad interpretation of public use, but where, as it happened, I think in 3 cases, a state Supreme Court said the general view is, the generally correct view is the narrow interpretation, but we're going to create an exception for these Mill Acts because of long acquiescence, then I think that is in fact a statement that the narrow view is the general view and is the rule, but we've essentially created an exception for this particular set of takings because they've been done for a long time. So I think it's reasonable to count that as saying that the narrow interpretation is the general view. There are also the 3 cases where they say we uphold this based on acquiescence but we don't. But they say nothing about what the general rule is there. If you have a case somewhere else where the state Supreme Court did in fact endorse either the broad view or the narrow one, then I look to that other case. And I think these are reasonable methodological choices, though I know we can discuss them further, but I do think the general way to, at the very least, to interpret a case where we say the general rule is X, but we're going to allow this one exception to the general rule because it's been acquiesced in for a long time, it's reasonable to interpret that, in my view, as saying that the general rule is X going forward. Now, Michael also raises a broader, deeper issue of what do we do when there is mixed evidence. One possible answer is to say when there's mixed evidence, then we don't rely on original meaning, we rely on some other kind of methodology. That's, I think, a perfectly legitimate viewpoint. However, if you take that view, it's not just the original meaning of public use over which originalism would give us no answer. It's the original meaning of huge portions of the rest of the Constitution. Think of the discussion in David Upham's paper yesterday about interracial marriage. Well, there were a lot of people, perhaps majority, who thought that the 14th Amendment would ban laws forbidding interracial marriage. Was clearly a minority view, and on not almost every, but in a huge range of disputed constitutional questions, there were at least some significant number of people at the time of enactment who differed from the dominant view. So to my mind, if you have a situation like this one where you can narrow things down to 2 contenders, which almost everybody agrees are overwhelmingly it's going to be the one or the other at the time. They did today. There are hybrid views, but at the time, very few people, if any, advocated a hybrid view. Then it's reasonable to say that the original meaning is the dominant view under whichever of the versions of original meaning you adopt, the expert version or the version as understood by the general public and so forth. I think, therefore, it's possible to say we're just going to throw up our hands when the evidence is mixed, but it's also possible to say, in my mind, more sound to say that what we want to do is look to which side has the preponderance of evidence, particularly if it's a fairly substantial preponderance rather than a pretty narrow one. Lastly, Michael says, what about usage, or what about what the legislatures did? I think he's right there. In the final version of this, there should be more discussion of that. For now, what I would say is I did discuss the kinds of Mill Acts that were in place at the time in 1791, and those Mill Acts virtually all of them were actually of the kind where they were public utilities. In the early 19th century, you get a more mixed set of mill acts, some of which look like the older 18th century ones, some of which are broader. I think there, in the states which adopted broader ones, a good many of them eventually had state Supreme Court decisions ruling on this. You might say, why should we privilege the views of state courts over the views of state legislatures? I think this goes to a sort of a deeper question, and maybe I should have discussed more. Also, I would say the court's view, other things equal, weighs more. First, because they are experts on the state constitution to a greater extent than legislators are, at least on average. Second, because the state legislatures in those states which struck down the Mill Acts, they did in fact acquiesce in it. So even the legislatures themselves recognize the court's superior authority in this area. But obviously, I recognize that this raises a deeper theoretical question, which I was perhaps wrong not to think about more thoroughly in the paper. So I recognize some people might say, no, actually the legislators are at least as important or even more important perhaps than the state Supreme Courts are. So on that note, I think I'll stop, but I very much look forward to the rest of the discussion. Thank you so much.
Okay, so time for questions now. We did get started a little late, and so we have a little less time than we might have had. With that in mind, sometimes in these situations, a group will invoke a sort of single question rule, which at least forces people to pack all of their questions into one rather than, have a series of questions and so forth. But at least maybe to just encourage you to think about what your most important comments are so that we'll have as much chance as possible for everyone to comment. Oh, so our first threesome is Tom Colby, Chris Green, and Will Bode.
Okay, so I've got 9 questions. I had a comment and a question. Michael pretty much made my comment that you go 16 to 9 to 2 or 10 to 6, as Michael thinks about it, that it suggests to me that there is not an original meaning here, especially if you think an original objective observer who is aware of all of this information in a very Gary Lawson sort of way would recognize that there's disagreement. There is no single objective meaning here. I think this is a great example of a point I've been trying to make. I think you're right that the point is broader than this, but I think it's a serious objection to certain kinds of originalism. The question that I have is perhaps there's a good answer to it, but I wanted to throw it out there. Later in the paper, you mention that Madison wrote a letter in which he says that if the federal government abolishes slavery, they'll be constitutionally obligated to pay compensation to the slave owners. I'm wondering, doesn't that tell us that Madison took the broad view of public use? Because here you're taking property from A and you're giving it to B. In this case, B is the property, which makes it different, but this is not as though the slaves are going to be made available, owned by the government or made available to everyone to use. You're taking property for some other good. As Madison wrote in that letter, he says, if slavery is a national evil to be abolished, and it be just that it be done at the national expense. So the public use here is serving the public good of ending a national evil. And Madison seems to be saying that one could do this under the Takings Clause. Why isn't, if the Takings Clause is the brainchild of James Madison, and James Madison said this, isn't that pretty good evidence that the original meaning on some theories of originalism of the Fifth Amendment Takings Clause is the broad one?
That's a good question. Oh, I'm sorry. I just have to wait for 2 more questions. I apologize. It's early in the morning. My mind, it doesn't function well early in the morning.
Chris and then Will.
So the question I would have under what I think the Privileges and Immunities Clause means is what's the consensus today? Is there a consensus today? And maybe this is material that you get to in the other chapters, but I don't really care I care what the Privileges or Immunities Clause meant in 1867, but I care about what the pattern of, the American tradition of civil liberty is today. So what is it?
So, unsurprisingly, my question is about the federal eminent domain power. And I guess I'm wondering, what makes you think that there's a public use requirement that applies to the federal government at all? So I look at the text of the Takings Clause, and textually, it's actually very hard to read the phrase for public use as a requirement for taking be for public use. I mean, you can question what's it doing there. Is it surplusage? Is it saying private takings aren't compensated? It's a little bit puzzling. But grammatically, it's odd to think that it says that the taking has to be for public use. Like, it doesn't seem to work that way. And then I wonder, is it historical? Is it that there's a public use requirement in British law? You don't talk about that, so I assume not. I wonder, is there specific evidence of people thinking about the few federal takings there were and thinking they had to be for public use? I didn't notice it when I was writing my article, and you don't talk about that either. Then that leaves you with, I think, sort of the general statements at a high level of generality that people believe in property, very, very much, and the claims about A to B, and like Calder versus Bull and so on. And the A to B cases are all state law cases, so that makes me wonder again what evidence there is that there's a requirement for the federal government to be for public use. And they could be explained by other things like the Due Process Clause or the fact that the takings from A to B are uncompensated. So I'm not sure, like, and certainly the fact that the states later all seem to agree their takings clauses have public use requirements makes me think maybe there is reason to think that the federal one does too, but I'm not sure what the evidence of a federal public use requirement is, and it'd be helpful to, since you sort of start the 14th Amendment discussion that way, it'd be helpful to know what's really doing the work there.
Yeah. So I guess I'll go in reverse order. Will asks, well, what about the federal government? I think I gave my answer to that in the last part of the paper when I responded to Jed Rubenfeld's argument that a response isn't especially original because virtually everybody rejects Jed Rubenfeld's argument except for Rubenfeld himself and possibly Will. But what Rubenfeld says essentially is that because it just says nor shall private property be taken for public use without just compensation, that just means that you have to pay compensation if it's taken for public use, but if it's taken for private use, maybe you don't have to pay anything at all. And I think the answer is that this was not the way it was understood at the time or throughout the really American history until Rubenfeld wrote his article in 1993, and moreover, things like Madison's letter, I'm going to talk about more in a moment, indicate that even when the taking is a transfer for a public use, even when a taking is a transfer to a private party, that it must be compensated. So I think just the overwhelming dominant assumption at the time and ever since was always that there's an implicit presumption here that there must be a public use. It's not linguistically necessitated by the language. Rubenfeld's reading, just looking at text alone, is plausible. So if you were a pure textualist and not an originalist, you could very well say, Rubenfeld is correct. But from an originalist point of view, it seems to be the case that everyone always assumed that there is that constraint. I would also note that in Calder versus Bull, which I'm looking at the text I quote here, Justice Chase specifically refers to, quote, to maintain that our federal or state legislature possesses such powers if they had not been expressly restrained would, in my opinion, be a political heresy altogether inadmissible in our free Republican government. So he's referring to both federal and state there, even though obviously the case deals with the action of a state government. So on the question before then, Shaswat, what is the tradition today? I'm not sure I fully understand the question. So obviously today, today the majority, it's complicated because there are 11 states which have specifically forbidden economic development takings, and state Supreme Courts have interpreted their state constitutions that way. That's not quite the same thing as interpreting a narrow view more generally. So as I discuss in the paper, in the mid to late 20th century, there are probably a majority of states, and certainly the federal Supreme Court, which took the broad view. This is relevant if you are not an originalist and you want to judge things based on what is common practice today. But if you are an originalist, I don't think that's very compelling evidence. Or maybe you have a theory as to why what they're doing today is relevant to the original meaning 100. Sorry?
It depends what you think the Privileges or Immunities Clause means or meant at the time it was adopted.
So if the Privileges and Immunities Clause means that the Bill of Rights is incorporated against the states, then it seems like what would be incorporated is the original meaning of the Bill of Rights, either as of 1791 or 1868. I think I see the point of your objection now, but if your view is that the privileged or immunities are whatever interpretation of the Bill of Rights states today have or think is fundamental, then I think that would be plausible. But that's certainly not the way incorporation has worked. And I don't think, historically, I also don't think that that's the best originalist view of what it means to incorporate the Bill of Rights. We can talk about that in more detail later. Finally, the very interesting question about Madison's letter about freeing the slaves and whether the federal government had the power to do that. Madison, I suspect, I don't know this for sure because Madison doesn't discuss this, but I suspect that Madison, if pressed, would probably say that it would require a constitutional amendment to do this for two reasons. One is that the assumption, as Will documents in his article, it was that the federal government didn't have a general power of eminent domain within the states, and obviously to free the states, or to free the slaves, most of whom lived in the states, would have required the federal government to use eminent domain in the states. And the second reason, obviously, would be the public use point. But even if you set aside public use, the first point would be relevant. So I suspect that to really carry out the scheme that Madison envisioned in this letter, under his view of federal power, at least, you would have to have a constitutional amendment. And of course, that constitutional amendment could override any public use constraints, just as it could override any limited powers constraints. Because what Madison proposes here, I think, is very much in conflict. If it doesn't require an amendment, would be very much in conflict with views that he had expressed for many years about what the scope of federal power is. So I think that was all three questions, right?
Yes.
Okay.
Let me know if you want to say anything, Michael. Okay, our next threesome is consists of Earl Maltz, David Upham, and Larry Solom.
I'm not sure if there's going to be a question here. There might only be observation. The first is, given, again, I agree 100% with Michael's issues about what do we do. The real question is what do we do with, and so maybe the best answer to we should reconceptualize originalism as an approach which excludes certain possibilities rather than generally gives us definitive answers, which I think would change the way the literature might be written about it. But beyond that, it seems to me also that what it also points to is that what we need is some presumptions when there is uncertainty. Right? So, and it also seems to me that there is no stronger reason for judicial activism, for lack of a better word, when there is uncertainty about the original meaning under an originalist theory than there would be under a living constitutionalist or non-originalist theory. So that for me, and this is just the observation, even though since it's mine, it's clearly right now, that I think that there should be sort of a Thayer presumption against judicial activism, which seems to me to be the logical thing, because again, if we don't have a definitive answer from originalism, we are essentially in the same place that we are in a non-originalist world with respect to the various different possibilities.
David.
There's a couple points. I'm probably a third person who agrees with Rubenfeld, at least in terms of looking at the text. It seems to me, and I guess this is, kind of what you commented to me yesterday, why aren't you doing things the way, why aren't you talking about the things I'm interested in talking about? But especially when you're looking at Kelo, you have to find something in the 14th Amendment to ground it. And there you don't even have a takings clause explicitly. You might have a due process clause. I think you can, my very tentative look at the historical research thinks you can find in due process both the takings clause as well as the principle no takings for private use. But I was, I might be a minority of three now, but the put Rubenfeld at the end struck me as putting in the wrong place. If the text is the first thing to look to, and then we're interpreting the text, if provided that's the method. And then secondly, I just wanted, this is just, before I open my mouth, I should ask, the letter you're talking about the letter of Madison to Robert Evans?
I can't remember the name of the correspondent, but I can look it up and see. Yes, Robert Evans.
Okay, because in the letter he does say that it's possible there's a constitutional problem, and we may need an amendment. But he says he says in the letter that there's a problem that we may need an amendment, Article 5 amendment, to be able to effectuate this kind of. But it's more. I don't think it's a Fifth Amendment problem. I think it's a 10th Amendment problem that prevents him.
Yeah, Really enjoyed the paper. Suggestion that if you want to speak to sort of public meaning textualists, that you need to have a fuller explication of the text. And just some ways in which you might do this. First, your contrast between literal and metaphorical meaning, right, is misusing the word metaphorical, at least as the argument is currently developed. You say that there is a broad sense of use, and if so, that's a semantic ambiguity, right, not a metaphorical use. And there's another ambiguity in the text, right, because the phrase public use is susceptible of two readings, irrespective of the meaning, of the conventional semantic meaning of use, accepting the narrow understanding of the word use. There is the possibility of use by the public, right, public use, use by the public, versus use for the public. Both of those are semantically possible uses of the phrase public use. On the Rubenfeld problem, I just would suggest that there's a fuller explanation as to how the text could communicate a limitation to public use. This would be I think you could get a fairly easy Gricean implicature explanation for how the text exactly as it is written, even though its semantic content doesn't include the limitation, would nonetheless communicate the limitation. So just the big suggestion is to have a more detailed, fuller explication of the textual problems.
So the points that Larry raises are interesting and actually raise some linguistic theory issues I may actually be not as knowledgeable about as Larry is. So it may be that we should talk in more detail afterwards about that. The point about use for the public is also interesting. I still would be inclined to say that that would also be a kind of metaphorical use of the term, much like use in the sense of, I'm getting a benefit out of this, so I might be said that I'm using it. But it's possible that we're understanding the word metaphorical in 2 or even 3 different ways here. So that may be also something we should talk about afterwards in more detail. On the issue of Rubenfeld and also the 14th Amendment, I think here the relevant aspect of the 14th Amendment is, does the 14th Amendment in fact incorporate either the Bill of Rights generally or at least the 5th Amendment specifically? And here I don't have a lot original to say except that A, sort of there's a lot of evidence that the Bill of Rights in general is supposed to be incorporated. B, if instead you believe in selective incorporation, virtually no one, to my knowledge at least, has argued that they believe in a form of selective incorporation that would exclude the Takings Clause. If there is in fact that kind of theory of selective incorporation out there, I'd like to know what it is and see what the nature of the argument is. Finally, on sort of presumptions in the face of in the face of divided evidence, I recognize that you could have a possible presumption that says when the evidence is divided, that means you get Thayerian deference. I think if this is true, this would apply not just here, but it would require deference in a wide range of things where both originalists and non-originalists, most of them tend to believe that there should not be deference. But I think it is a better view is to say that when the evidence is divided, we look to see which side has more evidence. If the evidence is roughly equal, maybe then deference applies. But if in fact there's a preponderance of evidence to one side, which I think is the case here, then it should be significant, then it doesn't counsel for deference. I would add also that if we're going to talk about presumptions, there is also a presumption against redundancy, as well as a a theory of the presumption of Thayerian deference, and as I suggested in my presentation, the broad view of public use does have the problem that it renders the words public use superfluous, because virtually any taking that benefits an individual also fits into the broad view of public use. To the extent that we're going to base things on presumptions, I think that presumption is at least as deeply rooted in the history of legal thought as Thayerian deference, which is a much more contested proposition.
Okay, our next group of questions will come from Randy Barnett, Larry Alexander, and Judd Campbell.
For this paper. Mine's more of a comment than a question, and it sort of picks up, or it was stimulated by Michael's comment on acquiescence, and then somewhat the byplay between his comment and Ilya's response to it, which, when Michael used the term acquiescence, it was sort of acquiescence to the general principle of law. When Ilya's responded to it, he said, well, it was acquiescence to these mill acts is what it was, and as opposed to any kind of general principles, the reaffirmation of the general principle rather than acquiescence to the general principle. And that might have just been a communicative misunderstanding about what Ilya had been claiming and Michael's understanding of it. But it gave rise, in my mind, to have some more thoughts about acquiescence and how I think originalists need to think about acquiescence. Since there really is no, one of the things that comes out of the paper, there's no great doctrine about it. It's not like we have a really great rule of law on how we deal with acquiescence, what we mean by it. One of the things like how should we think about it, or how would these things? Well, first of all, I think there's a problem in thinking of acquiescence as precedent, which is how typically things that have been done. Well, let me just give you a concrete example of something that's not related to takings that sort of is on the table here, and that is the Origination Clause challenge to the Affordable Care Act, because the bill, as a revenue measure, did not originate in the House of Representatives. It was supposed to. It originated in the Senate. We all know that. There's all kinds of disagreements about the Origination Clause, how it works and stuff, but let's just take for the sake of argument that it was unconstitutionally enacted under the Origination Clause. Well, one of the most powerful arguments against doing anything about it is lots of laws have been passed that way. And what are you going to do? Undo everything? You're going to go back and figure out every tax law, every measure that's been done in the past? Well, this is a pretty unhealthy reaction, meaning you can't ever correct a constitutional error without going back and undoing everything. In other words, every change you make back in the direction of original meaning has to be opposed on the grounds that it's revolutionary, too disruptive, when it doesn't need to be. It could just be incremental. It could just be the next time. So acquiescence could play a role. The concept of acquiescence could play a role if it's limited to things that have been done. But the thing, and you can't undo everything that's been done. But what you don't want to do is equate acquiescence with three other things. First, you don't want to equate acquiescence with precedent. Precedent is the establishment of kind of rule of law that goes forward in the future. That's really how the New Deal settlement was interpreted by progressives after the New Deal settlement, as establishing a rule of law. Everything else that came before is gone. We have this new world. We extrapolate into the future. There's a national problems power in Congress. If a problem is a national problem, Congress has a power over it. That's what the New Deal settlement meant. The Rehnquist court's approach was really one more based on acquiescence than on precedent. It basically said, everything that's been done has been done. We're not going to undo everything that's been done. But if you want to do any more, you better have a special justification for it, not just that it's been done before, and that special justification can't lead to the undoing of the first principles of the U.S. Constitution, which is really what I think was affirmed by the Roberts Court now, and accepted and affirmed by the Roberts Court and NFIB. This is kind of an acquiescence idea, but it's not a precedent idea. The second thing I think you don't want to do is equate acquiescence with consent, that we've consented to it by acquiescence. Acquiescence is really a different phenomena than consent. I acquiesce to a whole heck of a lot because I don't take up arms against the government or protect various interests that I have by use of force, or organize with others to protect my interests by use of force. I acquiesce to it, but boy, oh boy, I don't consent to it. I'm not even asked if I want to consent to it, and if anybody asked me, I would say no. But they don't even bother to ask me; they just take it. But that's not the same. But I'm acquiescing. There's no doubt. I certainly admit I am. I just don't consent to it. I don't think the two things are the same, and you can't draw one from the other. Finally, I don't think acquiescence equals amendment. of the Constitution either. I mean, it's not a proper way to change the Constitution. The Constitution remains, the meaning of the Constitution remains the same until it's properly changed. That's my specific variation on this rule of law point that Stephen makes. And it's not properly changed just because people acquiesce for a variety of reasons, like the reasons that motivate me to acquiesce. That's not a proper way to change the amendment. You ram something down people's throats, and then they don't have a revolution to stop you from doing it, is not a proper means of changing the Constitution. The Constitution remains the same, notwithstanding acquiescence. So I don't have a theory of acquiescence, frankly. I'm not arguing for one. I'm just suggesting that it would be useful if we start thinking about it. And if we realize acquiescence aren't these other things, it actually might prove a very useful means by which we can move towards original meaning without having to upset every apple cart that might be in sight, which would make moving towards original meaning more costly and therefore more difficult, and is the argument, one of the many arguments used against doing so in court and elsewhere.
Yeah, my point picks up on the point that Michael McConnell made about mixed evidence, and it's an intriguing question for me what the significance of the mixed evidence is. So we think of evidence as evidence of something, and here I take it the evidence is supposed to be of the public meaning of the public use portion of the takings clause. What you seem to get out of this is that there were different meanings. And then the question is, well, is it by majority vote that we decide what's the public meaning of this? I mean, the meaning held by most members of the public, or the members? It seems to me that there has to be a theory here of what it is that establishes the public meaning, as opposed to just pointing out that people disagreed about the meaning. Now, normally when we talk about disagreements about the meaning, we have some referent there that we want. So I read Rubenfeld to say this, and you read Rubenfeld to say that, and then we have a truth maker out there. What did Rubenfeld mean? And we can have different views about that, but we know what it is we're referring to. I'm never quite sure when we talk about the public meaning, and we have different people with different views of this, what the referent is supposed to be there. So what would make something the public meaning, as opposed to just different meanings. And I remember being, one of the advantages of age is that you can remember certain things that other people didn't have any firsthand experience with. I remember the pendency of the Equal Rights Amendment. And at this point, the Supreme Court had established a certain measure of gender equality under the 14th Amendment. And so then the question came up, well, what's the ERA going to do that hasn't been done by the court? And what was interesting is that the various things people could think of, various people, including supporters of the Equal Rights Amendment, disagreed about whether it would do, so would it create unisex bathrooms? That was the potty issue. People said, no, it's not going to do that. And then is it going to make women, subject to the draft? That was another thing that hadn't been done, and people disagreed about that. And so it became curious to me, sort of, was there anything that the Equal Rights Amendment was actually going to accomplish that wasn't accomplished? And one of the sort of vertiginous things is being a member of the public when it's the public meaning that's trying to be ascertained. And so my question is, so what's the referent that would make one of those views true, correct?
Judd, last question.
Okay, so I'm going to build on Will's and David's and Larry's questions. I got interested in two of the sources and pulled them totally randomly and read them very quickly. So I may have misread them, but I want to suggest that the two that I pulled suggest a different story. The first was the Gettysburg Case, which seems to be totally about federal power. Where do we get the power to create a national monument, and where do we get the power to pull to take private property for that monument? And there doesn't seem to even be a citation to the Fifth Amendment. I mean, they definitely talk about public use, but it doesn't seem to be one that's grounded in the Fifth Amendment. Maybe they didn't need it in that case, but it ties to the second source that I pulled, which was Cooley. And Cooley's argument seems to boil down to the key sentence that I found was, the common law has never sanctioned an appropriation of property based upon these considerations alone, and any such appropriation must therefore be held to be forbidden by our constitutions. And I think it's a principle of a limitation of the power of the state. And you could argue that that a limitation on the power of the state is just the flip side of a right. And maybe that's right with respect to within each sovereign, you have the limitations of power and you have rights, and they kind of coincide in a line. And so that's a good argument under state constitutional law, I guess, but why would that argument be incorporated? And how does that argument tie into whatever textual link you would have in the 14th Amendment? So, I mean, it's kind of an argument that sounds in the Obamacare challenge, and I don't take it that the principle of the Obamacare challenge is incorporated against the state governments, right? So what, I guess the point I would ask is that something that you see in the cases, or is that an idiosyncratic view, and actually these cases are talking much more about textually grounded rights that protect individuals as opposed to simply limitations on governmental power?
So I think I'll, again, go in reverse order. You ask about Cooley. It's true Cooley made some arguments based on the intrinsic nature of the common law, but he also made arguments based on the meaning of the words public use as used in state constitutions. I actually quote this on page 23 of my paper, where he says, quote, public use implies a possession, occupation, and enjoyment of the land by the public or public agency. And he also then goes on later on to say that the broad interpretation of public use, of course, he was well aware of its existence, is also wrong because it would make the words public use not a meaningful constraint on taking. So it's true he also made some other kinds of arguments, but the arguments I think are relevant to my treatment or to my article or book is his interpretation of public use, and I don't have to take a position on whether he was right or wrong about these other issues that he also raised. With respect to the Gettysburg case, in the Gettysburg case there were two issues. One which were raised by the property owners challenging a taking of their land, which was actually a taking for what is now the Gettysburg National Park. One argument that they raised that this was beyond the scope of Congress's enumerated powers, so a lot of the opinion is taken up in refuting that, but it was also claimed that it wasn't really for a public use, and here the court easily dispensed of that argument by saying, well, it is going to be owned by the government and it is for an enumerated power of the federal government, but then they also say, admittedly in dictum, that things would be different if this was a taking transferring property to a private entity. So in the rare case where the public use clause during this period was actually at issue because it was a federal taking, they did distinguish between takings for narrow public uses and takings that were not. That is contrasted with the other cases from the late 19th and early 20th century, which, because the Supreme Court had not at that point held that the public use clause or even a takings clause in general is incorporated, that you could only challenge a state taking in federal court by invoking sort of Lochner-era substantive due process. Now, I think it's Larry raised the issue about, well, what is the referent of original public meaning? Like, what are we referring to when what is sort of the truth that we're trying to identify? And I think this goes to the division among different theories of original public meaning that I point to. For some people, or for some versions, it's the understanding by the general public or by a hypothetical reasonable speaker of English who isn't necessarily an expert. For others, like Gary Wasson, it's the understanding by a hypothetical person at the time who is an expert. And I think these two theories of original meaning have different kinds of reference, and I try to address both in my analysis. Finally, obviously, Randy raises a lot of really interesting points with regard to acquiescence. I think there's actually an entire article there, and the comments that he made, maybe in an entire book. One point that I would, much more modest point that I would single out here is that even if we assume that acquiescence can justify some things that would otherwise be unconstitutional, it's important to ask, what is it in fact that people have acquiesced to? It could be the case that what has been acquiesced to is the general principle of the broad theory of public use, and in cases which said something like that, I counted them as endorsing the broad theory of public use. But it could be simply that we've acquiesced to this particular thing, the Mill Act, the use of takings from Mill Acts, but not necessarily to all broad interpretation of public use in general. And that version says, like, we're willing to accept this particular sinful behavior which has already occurred. We're not going to reverse it or punish you for it, but go forth and sin no more, right? And that is what several state Supreme Courts essentially said about that, and those, I think, are still endorsing the general theory of public use as a general principle, even though they're allowing the one thing to go through. To put it another way, think about something like Jefferson's view of the acquisition of Louisiana. He thought that it was unconstitutional, but he also thought that it was so important to do it that we should just do it anyway, and hopefully the political system will acquiesce in it. But he didn't, at least on his view, he didn't want to authorize a general sort of broad interpretation of the treaty power. What he wanted people to acquiesce in was the acquisition of Louisiana as such. Now, obviously, not everybody agreed with Jefferson. I'm not trying to make a claim about who was right in that controversy, but Jefferson's theory of what should be acquiesced in that instance is very different from a theory which might say, well, we're just going to acquiesce in the broad interpretation of this power going forward. And I think the same thing can be said about certain kinds of acquiescence with respect to public use, weeding aside the deeper issues that Randy correctly raises about, well, what status should acquiescence have in general? Even if they do acquiesce to the broad theory of public use, what does that actually mean? Should it have significance for originalists or not? I think that's a different and very important set of questions that maybe should be addressed at next year's Originalism conference.
I also wanted to react to Randy's comments. Even if I agreed with everything that you said, Randy, about acquiescence, we're not talking about a post-enactment acquiescence in this case. This is a section of Ilya's paper that's about the meaning of the 14th Amendment, and he's talking about cases that happened before the 14th Amendment, and he's saying that when the 14th Amendment is enacted, that it must have, or at least we suppose that they must have thought that the takings clause that they were incorporating meant what it has meant before. And in this sense, it seems to me acquiescence is extremely powerful evidence of the public meaning of public use, because if it's been acquiesced in, and this is, and there are a bunch of words here. It's not just acquiescence, it's precedent, it's longstanding practice, it's lots of legislatures. It seems to me that this is not we're not asking, when can acquiescence trump the Constitution. We're asking, when does acquiescence in a proposition prior to the adoption of the Constitution indicate something about its meaning? And and the second point here is, yes, I understand that that Ilya's argument is that there's a generally narrow interpretation of public use, and then they're carving out an exception for the Mill Act, that might be fine, except that the Mill Act is given to us in this paper as the paradigmatic example of the problem. I don't understand why give so much attention to the Mill Act if it's just if it's just the exception. I thought it was being offered to us as the most litigated example of where it matters, whether you take the broad or the narrow interpretation. And so I don't see why, if you want to dismiss the Mill Act cases as being just an exception, I'd like to know, why are they different? What are the other cases? I mean, again, the fact that we're not told what the other cases are about makes me uncomfortable here, because the only ones where we actually know what they're about seem not to fit the description of the cases. So that's why I think it's so significant for this paper that the courts seem to actually be accepting the Mill Acts.
I just want to very briefly clarify that what the Mill Acts are a paradigmatic example of is not all or even most takings of this era. They're a paradigmatic example of the evidence that is usually cited by the other side in this debate, and that's why I felt they had to devote a lot of attention to Mill Acts specifically. There were, in terms of what those other cases were about, some of them were about private roads and the like, others were about takings to benefit various kinds of industrial enterprise, and there were also various kinds of miscellaneous takings. You should not take away from this paper the idea that Mill Acts were all or most or even necessarily always the most important kinds of takings during this period. They were important in the sense that obviously mills in many states were important industrial enterprises, and they're also important in the sense that they've played a big role in the debate about this issue. Perhaps part of what I mean to suggest in this paper, and should have suggested more explicitly, is that it's important to take a broader view that looks at all of the cases, not just the Mill Acts. And when you take that broader view, you see this pattern. But I also felt I had to address the Mill Act specifically in detail, precisely because the other side in this debate has been citing them for a long time. And so if what you end up with is an ambiguous picture on the Mill Act, but a clear preponderance of evidence for the narrow view overall, then I think the overall picture is the one that matters more. But I think there also is reason to examine the Mill Act specifically because they played such a significant role in this debate over what was the understanding of public use at the time. And so I think Michael and others are right that I should clarify in more detail exactly how this piece of the puzzle fits into the larger puzzle, because the way it is, it's not that these are the most important cases necessarily or the only cases, it's that they're ones that have often been cited in literature that I'm reacting to.
Well, we have run over our time, so my apologies to Don, John, Shakira, Mike, and Jack that we don't have time to get to your questions, but thanks a lot to Ilya and Michael for this.